Hello and welcome to the final class of the Appellate Practice and Procedure course offered through Solo Practice University. We're going to talk today about tips and strategies for marketing an appellate practice. And I've got, as usual, the PowerPoint presentation set up in the blog post that makes up the course, this particular class. And I'm going to get right to it, and we're going to cover this topic fairly briskly today, and I'll explain why in a few minutes. The introductory slide is, as we say, we've reached the point now where we've gone through all of the process of handling an appeal, briefing, oral argument, and that sort of thing, and now we're moving on to marketing. And the assumption for this course is that you have decided that you want to pursue appellate practice as a practice area in a career. And so for that I say congratulations if that's truly where you are. If not, please continue to study the course materials, and again, as I said in the beginning of the course, it is a very fruitful and satisfying area for a solo or small firm practitioner to engage in. And so I'd certainly encourage folks whose interest is continued after taking the course to pursue it as a practice area. Having said that, what are some of the concrete strategies that you can implement to successfully develop an appellate practice? Well, the first is, if you have time still, is to build your resume. If you're a law student in particular, this is a tip that will apply probably more to you than to a lot of practitioners. But if you're in law school and you have the opportunity to do things like pursue law review or pursue a judicial clerkship, those are things that you most certainly ought to do. Law review is a very sought after credential. It's a highly competitive credential to obtain, and so it's somewhat difficult to obtain for that reason. But it's one of the areas where if you can get that credential on your resume, it can be a very positive development in terms of a perception that you would be qualified, whether it's accurate or not, to engage in appellate practice. And then a second major thing to pursue, if you have time and are able to do it, is a clerkship with an appellate justice. And by that I mean a federal circuit judge or state Supreme Court justice or an intermediate appellate court justice. And sometimes you may be able to obtain a course credit internship through your law school, and I've seen in my experience that these even will help lead to a paid position if that's what you're intending to do or want to do. But even the internship alone in itself can give you a pretty good window into what appellate practice might be like, and sort of the appellate decision-making process in particular. And I think it is, even by itself, if you don't have the time or whatever reason to obtain a paid clerkship, or are unable to obtain a paid clerkship, an internship is the next best thing, and I would encourage folks to do that if you have the time. But don't forget, even if you're a lawyer who has graduated, taken and passed the bar, maybe you've practiced for a while, it's not too late to get court clerk or court attorney experience. Judges do hire practicing attorneys, as sometimes you hear them referred to as career clerks or staff attorneys, and you can get just as valuable experience through those positions as you can through what we consider traditionally a law clerk position right out of school, usually a year to a 2-year position. All the same benefits are available in terms of a permanent or staff attorney position. And so, if you're fairly certain that this is what you want to do, and you don't have either a law review or a judicial clerk background, then by all means, I would encourage you, if you, again, have the ability and the time, and can afford what might be a lower paying salary than you can get out in the open market, I would encourage you to consider contacting the judges sitting in appellate courts in the areas where you either live now or are interested in living, and seeing if they have positions available for career clerks or staff attorneys. It can be an extremely valuable experience. Now, this is usually a little bit longer period than a judicial clerk position, but if you go and do that for a few years, it would be something that would be just a tremendous asset to your experience level and even to your resume. Those two things, the law review experience and a judicial clerkship or equivalent, will take you a long way down the road toward developing a successful appellate practice, just because rightly or wrongly the perception is that those are the types of folks that go on to become appellate lawyers, and that is the type of experience that law firms, if you're looking to get some experience at a law firm, will look for, and those are the types of experience that trial lawyers possibly may look for in hiring an appellate lawyer, or maybe even clients. And so it's not every successful appellate lawyer has this experience, but you will find by and large that most of them do. And I think it has to do largely with the fact that you're applying the same skill set, legal research and writing, in those areas in law review and clerkships as you would as an appellate lawyer. And so it's a natural fit that folks would tend to obtain those positions and then move on to practice appellate law. So don't get down if you're not able to secure those. It's not impossible to become a successful appellate lawyer without them. But if you have time in your career, it's just one of those things that you ought to consider trying to do if you can. Beyond the things, if you're in the here and now and you're out of school and you're looking at what you can do with your law license, there's some other preliminary things to think about. You're going to want to develop, in the next slide as we discuss, your reputation and your expertise in appellate law as a practice area. You need to be visible. You need to let people know who you are and what it is you're doing, that you are out to develop an appellate practice, and this is the area where you're going to be working in, and make your name known. You need to get to know specifically, not only on an individual basis, the courts and the judges, but you need to know the institutions. And I believe we've covered this in some of our previous lectures, that this goes into the expertise element. You need to be able to relate to trial lawyers and the people who would be hiring you a superior knowledge of those courts, so that you can add value to what it is that they would like for you to do for them. Another way of developing your reputation and expertise, primarily reputation, is to be helpful and forthright. Always, when you talk to trial lawyers or others who might be interested in hiring you, if you give away 5 or 10 minutes of your time to provide a little bit of advice, that's really just a good investment in business development for you. And then as far as forthrightness, it's really, as an appellate lawyer, it's absolutely critical that appellate judges be able to believe in you and believe that when you say something is the case, that it is the case, and that you're not someone who goes out and misrepresents the record, misrepresents the facts or the law, and that they can count on what you say as much as a judge can count on what any one lawyer says. And it's equally important for lawyers to be able to count on what you say. It's just, this is overall sort of a, just how you develop a good reputation in the legal community is by being as honest as you can with people, yet zealously representing your client, be honest with the court, and try and help the court in doing its job along the lines of what we talked about in the briefing section of this course. And another major thing that you can do to develop not only your experience but also your expertise in the perception of you as an appellate lawyer is to, if your jurisdiction offers it, to pursue specialization in appellate law. Offhand, I know of at least 3 jurisdictions that do. I think there are more than this, but Texas does, Florida does, California does. I believe there are several other states that recognize specialties as within certain practice areas, and appellate law is one of those that has gained a lot of momentum over the last 20 years or so as a recognized specialty. And so if you're practicing in a jurisdiction where there's a specialization or a certification of special competency offered in appellate law, and this is something you've decided to do is practice appellate law, then I think you need to set that as one of your first goals in establishing your practice, and then line out what it is you have to do to obtain that as a qualification, and just set it as a goal, and check off the tasks that you have to accomplish to get to that goal. Most often that's going to involve a very challenging exam at the end of a process that involves you obtaining a certain amount of experience, a certain number of oral arguments, writing a certain number of briefs, handling a certain number of appeals as lead counsel in not only the intermediate court of appeals level, but also your state Supreme Court or equivalent level, and just understand what it is you need to do to get from where you are now, wherever that may be, to being a board certified or equivalent appellate lawyer, and then doing it. So in the next slide, we list out here some traditional marketing techniques. These are things that appellate lawyers have been doing for years and years to develop this as a practice. The first is doing law work in the trial courts. We'll cover that in a little more detail here in a minute. Handling pro bono cases, writing articles, giving speeches, doing bar association work, committee work, some general networking areas such as with trial lawyers and judges, industry professionals, other appellate lawyers, and then advertising. I'm going to talk about, for just a couple of minutes, industry professionals and advertising, because we're not going to cover those in any great detail. We're not going to cover writing articles and giving speeches in any great detail. I'm going to go sort of in reverse order here. As far as advertising is concerned, what I really have in mind here, beyond what I'm going to talk about in terms of blogging and that sort of thing, is advertising in your local bar newsletters and that sort of thing. You'd be surprised at how effective a very small ad can be in helping to get your name out there and helping to generate discussion of you. I've run one for a couple of years at least, and it seems like every time I get ready to give up on it, maybe it's not the right word, but to not run it any longer, I have someone come up to me and say, "Oh, you're the guy that I see in the Austin Lawyer who advertises doing appellate work." So it seems to be a good reinforcement of the other efforts that I make in marketing my practice to get my name and my practice in front of other lawyers. So look and see what your local bar does in terms of advertising, and it's a good way to let people know. What I was just saying at the beginning, letting people know who you are and what you're doing. And this particular type of advertising can be effective. Otherwise, comply with whatever your local advertising rules are, but advertising to the general public is not a particularly effective approach for appellate lawyers, since, as we've discussed in other instances, in other contexts, most of your client relations are going to be with trial lawyers who have established relationships with clients who need your services, and so you're really reaching out more to trial lawyers than to anybody who would be picking up the yellow pages or looking at watching TV late at night when you tend to see a lot of the lawyer advertisements, even listening to the radio. It would need to be very targeted. Networking with industry professionals is sort of the same. There's sort of the same limitation on that. That's probably an effective way for lawyers in larger firms to develop appellate business. But for solos and small firms, really, it's probably not, just because from the standpoint of you have so few repeat customers in appeals. Your customers, again, are largely going to be trial lawyers and those who have direct influence on the cases that are going up on appeal. And so really working with the trial bar and the judges are going to be the most effective way for you to get your name out there. And so we'll cover some of that sort of networking approach here in a few more minutes in some more detail. I said earlier also that we're not really going to cover in detail writing articles and giving speeches. That is a very well-established business development strategy for appellate practitioners. If you've got a local bar, well, not even a local bar necessarily publication, but a state bar publication that addresses legal issues, write something appellate related for that. Get on the CLE speaking circuit, particularly if you can talk to trial lawyers about appellate related issues such as preservation of error, things like that they're going to be interested in. They're going to need to know and want to hear what you have to say on those topics, because it will help them in their own practices, and it will also help, again, get your name out there and get you known before those groups, so that when the people who attend those conferences have that kind of issue come up, your name will be hopefully at the top of the list of the folks they would think of in getting help from. So let's move on from the general list to some of the details involving these traditional marketing techniques. Law work, you might take a look at class number 2, how appellate lawyers bring value at the trial court level. We talk about doing law work in courts of appeals in quite a lot of detail in that class, and I've got some examples listed here. Strategic planning and analysis, motions, responses, and briefing, jury charges, error preservation. Those are the major areas where there are opportunities for what we've described as quote-unquote law work to be done in the trial courts, and that's a fertile area. If you can get established doing that kind of work, it's a great way to sort of break in at the ground level and get involved in cases early, and hopefully work on the appeals if they are appealed, and then as I frequently try and do, avoid appellate issues or shape appellate issues at earlier stages of the case. But the operative question is, how do you get that kind of work? And so that's the tricky part. You've got, again, to get yourself out there. You've got to get established enough to get that kind of work, and then you've got to do a good job for folks and get a reputation as someone who is available to do it and does good work. And it's all this sort of ties together. It's really not, you're not talking about a linear process for developing work. You're going to, for example, in the next slide we talk about pro bono cases. Well, how do you get experience handling appeals so that you can handle more appeals? One way to do that is to handle pro bono cases on appeal. It's a good opportunity to get lead counsel experience. It's a good opportunity to get oral argument experience if the Court of Appeals or whatever the court is that's hearing the case grants oral argument. And it also is a good opportunity, especially if you've got an organized pro bono program, to establish mentor relationships with other lawyers. In our program, our statewide program here in Texas, there's a mentorship element to it. And I know that there are a number of young lawyers who have worked on that program who've met more experienced appellate lawyers who they probably wouldn't have met otherwise, but for the pro bono program. So by doing things such as handling pro bono appeals, there is sort of an inertia that builds up over time, and you get more experience. You can market that experience. You can let people know that you've got X number of cases that you've handled as a lead counsel, and then they may be more prone to hire you to handle either their appeals or their law work in the long run. So pro bono cases are definitely an excellent way of getting experience under your belt that will help you ultimately in marketing your appellate practice. The next slide we talk about networking, and this is where we go into some more detail about some of the different elements of networking that were touched on earlier. The first is bar association work. This is in my view, this is a very fertile area for focusing networking efforts, because you have access through bar committees. Not just, don't just join your local bar association, but get involved in, the Judicial Affairs Committee or the CLE Committee, for example. Those are things that I've done and even taken on leadership positions in, and it's enabled me personally to meet other lawyers and judges and get to know them in a way that I never would have been able to do if I had just been just a practicing lawyer and not gotten involved in the bar and made these connections through the bar. A lot of established lawyers are involved in bar committees. Judges are frequently involved in bar committees. They attend these meetings, and it's a very good way of obtaining access to them on a very informal basis that will help build your own reputation as being someone who's a leader in the bar. And it helps you. You're going to get the opportunity time after time to meet people and tell them what you do, and eventually the word is going to get out that so and so over here is a new graduate of such and such school, and they came out of a clerkship with, Judge so and so, and they're looking to do appellate work, and they've established their own appellate practice. If you need that kind of service, you might want to talk to them. That's the kind of thing that's going to come up in cocktail conversation when these people are away and just chatting about their own practices and their own lives. So another major networking opportunity is with the trial lawyers, and it's the same basic strategy as far as getting access to people that you might not otherwise meet. But trial lawyers generally, they often have very what I call fact-based practices. They're taking a lot of depositions. They're trying to set up pleadings in cases where most often they handle the same types of cases over and over again. And so, they're working on developing the facts of the case more generally than the legal theories, and more than certainly briefing legal theories in great detail. And so a lot of times, because they're so busy, they're out of the office constantly taking depositions or at hearings, they could use help on the quote-unquote law work part of their practice. And so there's a good potential for folks who are looking to develop appellate practices to establish relationships with trial lawyers through the local trial lawyers association, or maybe there's a trial lawyers section of your local bar, and to demonstrate the skill set that you bring to the table, and to help build your reputation by doing contract work with these folks, or if you can build up a certain skill or experience level rather. If you can build up a certain experience level and get them to hire you for their appeals, all the better. This ties into what I was saying earlier about getting involved in cases early puts you in a better position to get hired for an appeal later, and relationships with trial lawyers is a good example of that. And then finally, as far as networking, you definitely need to get out and meet other appellate lawyers. And that seems a little contradictory in some ways, but I have found that it's a good thing to do, not only from a standpoint of seeking peer relationships or mentor relationships, people to bounce ideas off of. Particularly if you're going to open a solo practice, it's a good idea to know some other lawyers doing what you do to just kick ideas around. But even more importantly than that, appellate lawyers can't take every case generally that comes in the door, or if they have taken a lot of cases, they can't possibly handle their entire workload. So you might be putting yourself in a position by establishing relationships with other appellate lawyers to pick up some conflicts referrals or pick up some overflow work from some of these folks. And so those are generally good relationships to pursue as well. Now, those are sort of the traditional approaches to business development and appellate practice. What are some things that are available in the so-called Web 2.0 age? So we've got a slide that sort of outlines these. The first, we have listed here blogs, Twitter, Facebook, LinkedIn, JD Supra, and online legal directories such as Avo or Justia. Anybody who is viewing this video through Solo Practice University already knows what a blog is, and already knows more than likely what Twitter is, and probably already knows what Facebook and LinkedIn are. JD Supra and the legal directories, it's possible you don't. There is so much information out there available on these now that go and do a little homework, and rather than me spend time explaining, which frankly that would make this lecture too long and cumbersome to try and explain all these in great detail. But go and do a little homework on these. I'm going to talk really about blogs and Twitter, but Facebook and LinkedIn can be very effective networking strategy. It can be very effective as far as networking. Certainly they're important in terms of reputation, something that we're hearing about now called online reputation management, and just making yourself findable out there on the internet. Those are very easy ways to establish a web presence and to have create pages or profiles where people can see immediately what it is that you do, and your old classmates can find you. It's really almost a no-brainer these days in terms of establishing these pages. Now, one thing that I do not pretend to touch upon here is what your local bar's approach is to handling these as far as ethics, and whether you're dealing with advertising problems. The bars have handled it in a lot of different ways, and so consult your local bar and see if there's been like a local ethics opinion on these issues. But otherwise, do your homework. I've got listed at the bottom here that there are several SPU courses that address the topics in a lot of detail, and particularly blogs and Twitter. But look at the classes listed here, the professors in SPU. Look at their course offerings, and then whenever they talk about social media, blogging, networking, business development, marketing, those kinds of things, those are courses that you need to pay attention to. And the principles that apply in those courses are going to apply equally in appellate practice. So look at those courses, study the materials that are provided, watch the videos, and those will all give you a good idea about the kind of marketing strategies that are out there and available by virtue of the internet. I'm going to focus on two of them, and primarily the reason I'm focusing on these, aside from the fact that, again, it would just take too long to cover them all in what is really one class, it's because they're the ones that I have the most experience with in my own practice. I have a Facebook page, I have a LinkedIn page, I have a JD Super profile, I've claimed my ABO profile. Those are all things that I'm working on, but I'm probably not the person to look to as an example on how to implement those, because I've not done it as effectively as I could. I've been pretty actively involved in blogging, although my post frequency is down right now. And in Twitter, I've been fairly involved in it and was a fairly early adopter of that as well. So those are the two things that I feel most qualified to talk about from a business development standpoint. So let's spend a little time doing that. Blogging, again, anybody who's watching this through Solo Practice University already has a good idea of what blogs are about. It's a website, but it's not a traditional website. It's not an online brochure in the sense that you would ordinarily see those. It's something it's a special type of website published by a lawyer or a practice group. I've heard it described as an educational magazine that covers a niche area of the law, such as appellate practice, or a locale, such as Texas in particular. My blog is the Texas Appellate Law blog, so I sort of wrap up niche and location all in one area there. Blogs focus on a particular target audience. For me, it's people who are interested in Texas appellate practice, be it judges, other lawyers, in-house counsel, solo small firm practitioners, and those kinds. The content is distributed widely through RSS or internet feeds or email. And one of the biggest advantages to blogging is that the content is indexed on search engines like Google, which is just the big one to be concerned about. And you can also name the blog with a descriptive domain name that makes it easy to remember, like, for example, Texas Appellate Law blog. I think by now it's fairly established that blogging can be a very effective marketing tool for lawyers, and I would encourage anybody taking this class who's decided to go into appellate practice to start a blog. It can be as simple as covering the Court of Appeals in your locale, the most local appellate court. It can be covering appellate issues in your jurisdiction. There really are not any limits to the topic that you pick, other than I think the conventional wisdom would say pick a pretty narrow topic. Texas appellate law is both narrow and broad, and so it pretty much allows me to cover whatever I want. If I were going to create a blog today, I might create one that is I don't know, Austin Court of Appeals blog or something like that. And I'm surprised nobody's done it yet. I don't think that's happened. But I think that also is a testament to the power of blogging. It requires some work. Don't make no mistake about it. It requires some work, But once you commit to it and follow through on it, and capture a particular niche, it may be more or less your niche to fill, and so you can capitalize on that and use that to sort of launch or springboard off of that to market your practice within that particular niche. So if you have a niche within appellate practice specifically that you want to fill, I'd highly recommend starting a blog and showcasing your knowledge and using that as a marketing tool. They're easy to start. They're not expensive. You can get a WordPress theme, very inexpensively, and get it hosted very inexpensively. But blogging in particular, aside from commenting on a specific niche, helps you to become recognized as an authority in the subject that you're blogging about. It makes it easy for people to find you, referral sources, potential clients, and I would say, perhaps most importantly, the media. Take a look at the link here. There's at the bottom of this slide about blogs, newsflash, appellate judges read blogs, and you'll get an example of what it is I'm talking about. After I'd been blogging for quite a while, probably going on a couple of years, it got to where I would run into appellate justices at seminars, and they would comment about what I'd written about the previous week, or more recently, commenting about the fact that I haven't written very much recently. So, it really, as surprising as it might seem to some people, it is absolute truth that appellate judges and many, many other people actually read blogs. And so if these folks are reading blogs and looking for folks who are writing about content specific to your jurisdiction or your niche practice area, then it can be a tremendous advantage for you in terms of getting known in the appellate community to write a blog and maintain a blog addressing that particular subject. I can't say enough about it. So I'm going to provide now, real quickly, some samples of appellate blogs that you might want to look at to get some inspiration. The first is the SCOTUS blog, which is it's now written by the Supreme Court practice, the appellate practitioners over at Aiken Gump, a national law firm, but it was started by Tom Goldstein when he was a sole practitioner, and he may have had one or two partners at the time, but practically a sole practitioner doing a lot of appellate work. And so this is one of the better known appellate blogs in all of the country. They do a really good job of covering the U.S. Supreme Court. And now, of course, they've got the power of a large firm behind them, but I think it really benefits this group that it was started and obtained quite a following when Tom was at a small firm. And then Illinois Appellate Lawyer blog is Steve Merricken, who's somebody I'm familiar with and have actually worked with. Just another good example of the kind of thing that you can do with blogging about appellate practice. Greg May out in California, the next slide, the California Blog of Appeal. He and I have very similar practices, and I think he has a really good blog that focuses on California appellate issues. And then I'll give you just a quick snapshot of mine. You can all go visit it anytime you want to at TexasAppellateLawBlog.com. And you see a lot of variation in designs. There may be in some of the other SPU courses some focus on obtaining design services or getting themes to use for your blog. I've had mine professionally designed by a service that really focuses on lawyers, but there's just an infinite number of possibilities for how to set up a blog, and not knowing how to do it really is not an excuse for not doing it, because there are all kinds of resources out there available. And if anybody has a question about that, feel free to contact me, and I'll get you some resources on how to do it. I mentioned that one of the advantages to blogging was being able to be found in the search engines like Google, indexes. The next couple of slides show some examples of that. These are Google searches that were run actually some time ago. I redid them before preparing these slides just to verify that the results were still pretty accurate. But In this first slide, you see a Google search for the terms Texas Appellate Lawyer, and I've got some arrows sort of describing what some of the contents of this page are. That's the search term. Over on the right-hand column, you've got some paid ads, and on the top, you've got some more paid ads. But for that search term, for Texas Appellate Lawyer, for probably at least a year or maybe more now, my blog is the number one, has a number one ranking for those particular search terms, which means anybody throughout the world running a search for those terms is going to find that link, my blog link, TexasAppellateLawBlog.com, coming up number one. And so what is your natural tendency when you run a search and you see a page like this come up? You're going to focus on the first few links that you find. And so this demonstrates the power of search engine optimization and blogging generally, that this is how easy it is for someone to find me, and really anybody who puts any kind of effort into blogging will have, I think, a very similar outcome, because you don't have to have a professionally designed blog to get really good results on SEO. All you have to do is put up good content and put it up regularly, and the search engines are going to find you. They're going to find your blog, and you're going to get ranked fairly high. Just the next slide is another example, just using the search term Texas Appeals. I don't come up number one on this one. I'm I guess technically third. One site is one of our appellate court sites here in Texas, and another is another variation of a Texas appellate court site, not a private practice lawyer site. So I'm content with being number three in this search term for Texas Appeals. So that's just, again, another example of how powerful blogging can be in terms of getting you the presence it helps you establish on the internet. The next slide is yet another example. Sometimes by putting up blog content, it gets syndicated. As I said earlier, it gets syndicated through RSS syndication or email, and RSS is picked up, across the internet. And Wall Street Journal sometimes will republish things that it finds in the law blogs. And this is an example of one. I have to thank Greg May for. I posted about a post that Greg did on the reluctance of some in-house counsel to hire appellate lawyers, in-house counsel and trial lawyers. And so I kind of commented on Greg's post, and my post got picked up by the Wall Street Journal Online and republished. And so this is an example of how one blog post can have a very far-reaching effect if it catches someone's attention. I should also emphasize again that blogging, by putting you out there in the public eye, does allow the media to find you as well, and you very well likely could get calls from journalists, wanting comments about cases, wanting analysis about cases, and otherwise, again, it's a good way of contributing to the buzz about your practice, is to have people be able to find you easily, and then when they do, when journalists call, for example, be in a position to comment on whatever the issue is. So you might ask, well, where do I get my blog content? Well, that's really not that difficult. Blogging is kind of fun and interesting, and there are days that I would rather sit down and write blog posts than actually do some of the paying work that I have, just because there are things I can write about, things that really interest me. But here's the slide. Sources of blog content has some readily identified sources, cases, online news articles, information that you get from CLE conferences or seminars that you attend, bar publications, things that you find, as the example I just gave a minute ago about a post that I did commenting on one of my California brethren's blog posts. Talk about what other people are saying. There's a certain strategy and a certain culture that goes along with blogging, and mostly it has to do with, again, be honest, be forthright, and give credit where credit is due. And it's perfectly okay to post about what other people are talking about, because it recognizes, not only do you put your own information out there, but it recognizes what other people are doing and helps build the buzz about, not only you, but the person you're talking about as well. So it's legitimate to join in the conversation, as is often said, with respect to blogging, and comment on what they're saying, and that way, it really benefits everyone. How often do you post? Well, part of it depends on what the approach you're taking to your blog is. If you're looking to be a news reporter, like talking about the Supreme Court in your jurisdiction, you're going to sort of be a slave to whatever the court does and when it releases new opinions and that sort of thing. Another approach is just to blog about issues that interest you and provide a more in-depth analysis than just an announcement that the court has released a certain number of decisions. There are plenty of good blogs that do that, and then do both. Follow up with an order list, and then have also some in-depth analysis of cases. So it's not a really either-or proposition, but you have to balance posting good content regularly with the perception that you don't have enough quote-unquote real work to do, so you're sitting around blogging all the time. So I think there's a certain danger in over-blogging, if there's such a word. Those who have busy practices don't have time to be blogging every day, frankly. And I'm not sure that you want to blog every day. But as a practical matter, putting up a couple of relatively short posts, a couple of 3 paragraphs, a few times a week, once or twice a week, is probably enough to really have an impact. I think the research shows that more than a few paragraphs, you're going to lose the reader's attention. And so I would say if you have that much to write about a particular case, consider writing an article for your bar journal or something like that. But it's sort of an art form, blogging is, and it's one that takes a little while to learn and get the hang of. But once you do, it does become, I would even say, cathartic. It's something that you enjoy doing. If you enjoy writing and enjoy keeping up with what's going on in your jurisdiction, it can be a very rewarding thing to do just for your own self. And then, one of the nice sort of side benefits to it is using it as a business development tool. But either way, I think it's a worthwhile activity, and certainly if you're trying to develop an appellate practice, it's a very worthwhile enterprise. All right, so let's spend a few minutes talking about Twitter. As I said, most everyone who is watching this video, certainly those who have been taking classes with Solo Practice University, already know what Twitter is. But it's just for completeness, I'll add that as the slide says, it's a free service that allows participants to publish short updates, which are also known as tweets, that answer the basic question, what are you doing, or otherwise just provides a status update. I wrote an article for Texas Lawyer that's linked on this slide, Marketing Your Practice in 140 Characters or Less. I would suggest that you read it because I think it comes at the idea of business development through Twitter from a very realistic perspective. There's some tips in there about what to do, what not to do, and I think maybe addresses a little bit of the skepticism that people have had about Twitter as a business development tool. I really intended the article to address a much larger audience than just appellate lawyers, but I think if you read it, it provides a good overview for how you can use Twitter as a business development tool. And I also mentioned just briefly that Texas Lawyer actually approached me about writing this article after noticing that I had put up some blog posts about Twitter. And that also it wound up getting republished on law.com. So this article is itself a pretty solid statement for the power of blogging, just by virtue of the fact that the media sought me out to write about this particular topic. And even since then, they've approached me. I wrote a second article about Twitter, and now I seem to be on the radar for the folks at Texas Lawyer and their affiliate, their parent company, to write articles, just because they've, through this device that I started working with, 3 years ago or so, I've established enough of a reputation and put out enough of myself on the internet where folks who read it apparently are comfortable contacting me and asking me to comment. on things or write articles about certain issues. And so, that is a testament to the power that internet-based marketing brings, and particularly blogging, and I think even Twitter, which can be used as a really good complement, as is discussed, I believe, in the article that I wrote that's linked here. It can be a really good complement to a blog as well. It helps publicize your blog in a way that the blog alone won't do, and it helps engage the audience who may be reading your blog or reading your Twitter posts in a way that just one or the other alone won't do. And I got just an image showing that article as the next slide. And also just an image just demonstrating what the Twitter homepage looks like. Again, most everybody who watches this video is already going to be familiar with it. All right, so, well, that pretty much takes us to the end of today's topic, and unfortunately to the end of the course. I don't intend to just ride off into the sunset. I intend to supplement the lectures that you've been able to watch here at Solo Practice University by posting to the online classroom. Now that I've completed the lectures, I should be able to post periodically to the online classroom on subjects that are related to what we've talked about in the course. And so I intend to do that. I'm going to stick around. And also, for folks who are watching the lectures, as always, please feel free to contact me on the group wire. Send me questions, and a very easy way for me to come up with content to post about is if I get questions on appellate practice that I can respond to in a blog post or on the group wire, and I'll do my best to try and do that. I hope that you have gotten something out of this course. I realize that I've had to be quite general in a lot of the topics I've discussed because there's a lot of variety among the different jurisdictions for folks that could be watching these videos, and I've not wanted to lecture specifically for this course about Texas appellate practice. That may be the topic of another course that I teach online someday, but I've tried to give an overview of appellate practice from the perspective of someone who's done it not only as a big firm lawyer, but now for 3 years as a sole practitioner and small firm lawyer. And so I've learned a lot about it in both areas, and feel pretty comfortable with being able to express whatever knowledge that I've obtained in that period of time and share it with folks who've watched these videos. And so I'm very grateful for your attention. I'm grateful to Susan for the opportunity to lecture on this subject at Solo Practice University, and I wish you all the best in your practices and in life. Thank you very much for your attention.